Hello, everybody. Welcome to Chatting with Charlie, EB5 Investor Outlook for April of 2025. My name is Joey Barnett. Thank you all for joining. For those of you who are watching on YouTube, please click subscribe. We have a lot of good content coming from WR Immigration about all of the important immigration updates. And we have a very special program today. Charlie and I do this on a monthly basis, but today we have the pleasure of having Bernie Wolfsdorf join us. Bernie is the managing partner of our firm. He is an EB5 All-Star. He is the former AILA president nationally. And what I like about Bernie is that he provides a very unique perspective that I just don't think a lot of people get. And so I'm really, really happy that he's able to join with us today as we talk about the limited window of opportunity for EB5 investors. So Bernie, Charlie, so great to have you on today.
Thank you, Joey. Honestly, what is it now? More than 10 years we've been working together, and it really is a pleasure because you have such a deep insight. So, since Joey's introduced me, I'm going to kill a minute or two while people log in and log on and introduce Charlie, even though you do it every month. So, for those of you who may have forgot, Charlie was the director of visa controls for the United States Department of State for some 23 years. And I like to say he's probably the only one who truly understands the Visa Bulletin. So thank you, Charlie, for adding some clarity. And then Joey is now the big shot. He's saying I'm the big shot, but I'm the has-been. Joey is the current vice chair of the AILA EB5 committee. That's a really big deal. They kind of kicked me off the committee this year. I guess I've been on it too long. So Joey is now the big boss over there, and he's on the editorial board for IIUSA and really has an incredible grasp of this topic. So we're going to jump in here, go through all the latest information, focusing on primarily the April Visa Bulletin. Those are the three guys. Well, I say my picture's a fake picture because I'm much older than that now. And Joey, I think you look better with your beard, quite frankly. A little bit like George Clooney kind of look there, Yeah,
I appreciate that. Thank you.
definitely George Clooney. So just to make a little humor while people join, you know, EB5 Investor magazine, they gave me this all-star thing, top 5, but the real power list is the top 25, the EB5 top 25. And who's on top of the EB5 top 25 list? None other than the famous Joey Barnett. And then I discovered it's alphabetical, Joey. That's why you're on the top of the list and everybody chooses you.
It's
Um,
helped me my entire life and continues to do so. So I
but
can thank my father for that one.
I'm gonna release the secret. At the bottom of that list is Vivian Zhu, and she doesn't want to participate in these things because she's just sitting there doing the work, getting the cases filed. I don't think anybody's filed more cases than Vivian Zhu, and I don't think anybody is better on some of the complex issues that arise because she's seeing all the RFEs. You know,
She's incredible.
she's incredible. So she's the third partner on our somewhat large team. I think we've got probably about 25, 30 people altogether if you count in all the adjustment people and the consular people. So, we're pretty proud. I'm pretty proud of the fact that we have this power team, and with Charlie helping us navigate through the critical visa supplier issue and some of the DOS issues. So, Charlie, Joey, and I have been talking a lot. What are your initial comments about what happened in the April 25 user bulletin before we drill down with the actual slides?
Basically, the State Department made a decision that they could no longer provide numbers to China and Indian applicants. They had to retrogress the date to basically stop any future number use by Indian and China applicants in the unreserved EB5 category in order for there to be remaining available numbers for rest of world applicants who had not yet reached their per country limit.
Charlie, this is like, I mean, jaw dropping stuff, right? I mean, we're only in March. we're still in Q2, and effectively what they did is make visas unavailable to India and China. I mean, there's nobody with those early priority dates, or virtually no one with those early priority dates. So this is the equivalent of just closing the tap completely for the unreserved categories. So we're not talking about the new program RIA. We're not talking about where the news remains pretty damn good still. But for those people who've already filed, this was a shocker, right? I mean, I didn't expect it.
I believe early in the year when the October Visa Bulletin was published and we did one of our early broadcasts on it, I think I did mention at the time that I was very surprised that the China and India dates for final action dates had been advanced so dramatically, as with the application filing dates. If I had been doing it, I would have made the movements more incremental so that I could monitor the demand, because it's very important that you do so in order to determine if your estimates of number use based on the final action dates are going to prove accurate. Otherwise, you may overuse numbers, which I believe is what state has done. More China and Indian numbers have been used than they expected. And now there is more rest of world demand that they also had not expected, so that they have to make these dramatic retrogressions. I would not expect any forward movement of either the China or India unreserved date for the remainder of the fiscal year.
Incredibly valuable. I mean, just to draw it in what I call Bernie simplistic analysis, it's sort of generally the way you did this, Charlie, is you go step by step on the ice because you don't want the ice to break. And they seem to have just driven out into the ice and in the middle of the river and everything collapsed, right? I mean, I know that's a weird analogy, but you would do it more gradually so that we don't have these dramatic things happening that, quite frankly, have shocked the industry. I mean, for people waiting in those lines, waiting 8 years, 9 years, and then suddenly, bang, the whole thing shuts down. That's kind of a little demoralizing, right?
Yeah, the only one thing that I can think of is they may have tried to expedite the processing of unreserved visas in the early part of the year in order to free up staff time in the latter part of the year when they were receiving more reserved visa category petitions approved, and that they could, start processing more of the reserved. So that's a possibility.
So, but Joey, I know you were studying these numbers as well. I mean, Guangzhou was doing almost 1,000 cases a month, right? In the last month or two. Is that correct for unreserved?
Uh,
Do you remember those
I'm not
numbers?
sure off the
I
top of my head how many they had
but
done. I think they had done certainly over 3,000 for the first quarter of
but
the
it was
fiscal
pretty
year.
high for the first quarter, right? I mean, at the end of the day, what Charlie's saying is that they were steadily moving forward.
But
So
I agree with you, though, Bernie. It is demoralizing. I mean, we've had a lot of consular interviews at Guangzhou canceled, right? And that's just incredibly demoralizing. And as Charlie mentioned, we're unlikely to see those final action dates become current for the rest of the fiscal year. But I also want to just make sure people understand that this does not impact any post RIA investors and their ability to file an I-526 and the ability to file an adjustment of status at the same time if they're in the United States. So what we've been talking about is for pre-RIA investors, and in particularly Chinese investors who've been stuck in these incredibly long visa backlogs for nearly a decade. And as well for some Indian nationals, though, just the numbers aren't as big as the Chinese.
I just wanted to go through the legal disclaimer. I know we're not at a full size here, but this doesn't constitute legal advice. For legal advice, please contact us. That visa law at Wolfsdorf actually comes to me.
Today, we're going to be talking a little bit about any updates to President Trump's gold card proposal, and we're going to be getting into the data and getting Charlie's insight on what exactly happened in this April 2025 Visa Bulletin and what we can expect for the rest of the fiscal year.
So starting off with what we're going to call President Trump's gold card, This was that shocking moment in the Oval Office with Secretary of Commerce Lutnick standing next to him with Deputy Chief of Staff Miller, and they announced this gold card. So, Joey, tell us a little bit about the difference between the gold card. I mean, by the way, that was 3 weeks ago, and they said in 2 weeks' time, we're gonna replace the EB-5 program with this new gold card. And just last week, they said there's 250,000 people in the waiting line for the gold card. What were your comments about when you saw that, Joey?
My comments were they haven't opened it up, so how could there be a waiting line? I
Yeah.
don't know what he's talking about, but I the plan, at least from what we understand, is it's completely separate from EB-5. There's no job creation aspect. There is no investment aspect. It is a donation to pay down the national debt. And I guess there are some tax differences that may be provided. Everything that I seem to understand about this seems to think that there would be an act of Congress to require this. My thought is that if a president could just create a path to citizenship by himself, some presidents would have tried that beforehand. I just don't think there's authority for a president to do that without Congress. And so when people talk about, well, is this replacing EB-5? I say, no, not right now. And now there's sort of a little bit of a pushback. It's sitting next to EB-5. In my view, this has caused potential EB-5 investors to go one of two ways. One, sit and wait and see, which could actually be paralysis by analysis and could impact their ability to file an adjustment of status if the final action dates are no longer current in 6 months. Or I see people who are trying to invest as fast as possible. And I would agree that those people who are filing today are in the exact same position legally as somebody who filed last summer after this Trump, press conference, right? There's no difference between someone who's filing in March of 2025 and someone who's filing in September of 2024 based on the law.
And you base this on the fact that in the RIA, it specifically says provides a so-called grandfather protection for all cases filed prior to September 30th, 2026. That's the law of the United States. And the regional center program technically expires in 27. So those people who've decided to file, and I think they're large numbers, Joey, because from what I'm hearing, numerous projects are quite frankly just sold out. I mean, even getting a slot right now in a good project is quite difficult because, yeah, there's projects on the market, but a lot of the popular ones have sort of actually sold out already based on this, pardon my use of the term, gold rush for the RCs.
One thing that I say, about this is that could Congress potentially change this law? Yes, I guess they could, right? I mean, they no one's going to stop them, but only 3 years ago, they all agreed that they wanted this. And so I don't think much has changed since then. I don't think that they want to screw over good faith investors who are investing this money and creating jobs for US workers. I don't see that being something that Congress would do.
And at the end of the day, the Republican majorities in both the House and Senate are really small, right? The Republicans are very disciplined. They're voting together, but they don't have that overbearing authority. I mean, yeah, they got majorities in the House and the Senate, but they very narrow majorities. And I think to do this kind of retroactive legislation to rip up, yeah, technically they could, rip everything up. But the reality is hopefully the courts will provide some balance and hopefully they will see some benefit to having a system that is reliable. I mean, if you can't rely on statutes, what can you rely on? So, yeah, look, I think this gold card is a lot of hot air. And it was very interesting. President Trump actually said, I have no idea. Maybe, they're going to raise 50, what is it? 50 billion, trillion? I forget how many zeros. And we're going to pay off the national debt and have 15 trillion left over. I mean, that is fantasy, pie in the sky, showing this stuff wasn't really thought through. And then President Trump says, but on the other hand, maybe there'll be nobody who invests. And I think he kind of got it right on that second statement, because I can't imagine, other than possibly a few oligarchs, who are going to pony up 5 million. And by the way, Joey, they're surely going to, they talk about extreme vetting. It's not like they're going to be able to avoid things like source of funds and proving the money's legal, right? I mean, at the end of the day, they're not going to take dirty money in here. So how do you do a 5 million source of funds on an oligarch? Where did you get the money to invest? Blah, blah, blah. Those cases wouldn't be that straightforward anyway. And there certainly aren't 250,000 of them. Maybe at best there's like 50.
I agree. I don't think it's that many, but I mean, we've been reached out to by certain people who are interested in it. I mean, it's not like there isn't a demand for it. So I guess there could be something there. I just, at this point, nothing official has been given. And so I'm telling people, you just keep moving forward with your EB5 plans as if this never happened. It's something to have in the back of your mind, but until I see something official, I'm not changing how I'm acting.
And Charlie,
Yeah.
just shooting over to you, the EB1, 2, and 3 categories, which is the other alternative for many of the people in the US, they're not moving very much either, right? At the end of the day. So there's, other than marriage to an American citizen, there aren't too many pathways. Am I accurate on that, Charlie?
Correct. The wait times in the employment first, second, and third preference category for Chinese and Indian applicants is growing longer. There are not as many visa numbers available. And in the second and third preference category, both China and India are basically subject to their per country annual limits, which are very limited.
And then when we switch over to the family immigration, it's even worse, right? Those waiting lines have gone from ridiculous to absurd. I'm talking about like F2B, F2A, spouse of permanent resident, minor child, not too bad, but F2B is absurd, first preference absurd, third preference, and let's not even talk about fourth preference, because that's 20 years. And the family waiting lines are also crazy long. So this fifth EB5 program for people who've been in the United States on H-1Bs, for example, for many years, provides one of the very few options for people to be able to do concurrent filing, get their 5-year work card, and not have to worry about being laid off from their job and deported, right? I mean, this is something that's, quite frankly, pretty much the only thing that's open for people. And if you're from India or China, even if you are first preference professor with, 550 publications, you're still stuck in a horrible waiting line.
We have a good question here. This will be for Charlie. How many days do you think the China unreserved will move forward in the next fiscal year if the current rest of world trend continues?
That's the good question.
My hope would be that they would try to have a complete or major recovery, moving the October final action date back to the in China to the July 15th, 2016 final action date, and in India to the January 1st, 2022 final action date. Hopefully, because in October they will have a new supply of number. And again, hopefully they would try to do a recovery. That may not be possible based on the amount of pending demand. But again, that would be a best case scenario. If that were to happen, then people should not expect the dates to advance in 2026 for a period of time.
So, Charlie, in the old days when you ran the show here, Chart B would be something you could really rely on. It would give you some idea, some visibility as to, where you could plan on being and when you could get ready. They don't seem to move Chart B anymore, right? I mean, it's not a very strong indicator of when to get. I mean, it's an instruction to the National Visa Center, so they're going to issue what we call Packet 3 based on these numbers, but they don't seem to move it.
Correct. Typically, the application filing dates listed in Chart B are announced in October, and they basically stay where they are throughout the fiscal year unless it is determined that demand is much less than expected. But as we will see in a later chart, as I mentioned earlier, these dates for at least for China were totally unrealistic. But one other thing to mention on these dates is the U.S. Immigration Service can only accept adjustment of status application when they feel that there are numbers, quote, immediately available for processing in that fiscal year. And that is why sometimes they will stop using chart beat dates to allow applicants to file, as they did effective February 1st of this year. They said at that point, only chart A dates will be allowed to be used.
No, but generally, we can anticipate they will allow Chart B adjustments in October and November. So we're 6 or 7 months away from being pretty confident that Chart B. So if let's assume I'm from China and I have a September 2016 date, pretty good chance that I will be able to do an adjustment of status if I'm lawfully in the US at that point. Is that your speculation?
I would not be confident in that statement. I believe there is a good chance that they will retrogress at least the China application filing date when they release it in October, because they will realize that this was
Too optimistic.
much too optimistic. Again, the Chart B dates in theory are where the State Department, in consultation with USCIS, expects the final action dates to be in September. This is obviously, with this recent retrogression, these dates were obviously unrealistic.
What's so strange about this to me is that, they put that footnote in the January Visa Bulletin about reserved, but they didn't have anything about unreserved retrogression or anything like this. I mean, this really came out of the blue. Normally, if there's something like this, wouldn't you think they would let people know about it beforehand?
Yeah, at the beginning of the year, I would have made estimates on how many numbers I thought were going to be available for China and India use, and established the final action dates and application dates based on that. I would have continued to monitor to determine whether my estimates were accurate or need to be adjusted. The fact that there was no warning about these retrogressions happening, to me, indicates that state may have been caught totally off guard in terms of the demand coming in, and realized they had no choice but to immediately have a dramatic retrogression to stop number use by China and Indian applicants.
It's caused a lot of anxiety in the community. So let's do a little drill down on the March versus April Visa Bulletin. I mean, we've showed it in the previous slides. Here we have them together. This is what we're talking about. In March, chart A shows, respectable numbers, not exactly moving fast, but I actually got a July 14 interview scheduled in Guangzhou, July 14, 2016, just made it, literally with 1 or 2 days. But starting in April, that person would be stuck quite horribly. And I'm kind of nervous if they don't get through at the interview and there's some missing document, then they sort of going to have to wait quite a while.
I have a couple clients who got completely screwed, and they had their appointments scheduled in Mumbai in April. They filed in 2022.
And they got canceled, right?
It has not yet been canceled. I'm waiting for that to come in. I'm prepping them to go, but I imagine that's going to get canceled. I mean, this India retrogression pretty much means, there was a big surge of filings in November 2019 before like the program ended. So they're pretty much saying anybody who filed right at the end of that period there, you're not going to be able to move forward if you haven't already. And then pretty much all of the sort of pooled direct EB5 cases, those are also kind of put on hold for the time being.
Yeah, this was a shocker for those people who've been patiently waiting in line, thinking they were close, to discover that they're going to have to wait until October 1 for the new fresh supply to come on the market to sort of get back on their feet, as it were. So, and now the warning came in Note E folks, if you follow the Visa Bulletin, yeah, you look at chart A, that's for issuance of visa. Chart B, get ready, and sometimes use it for adjustment. But read the notes as well. We get all this, what I'm going to call scare 'em stuff. What you said, Joey and Charlie, is that we should have had this note 2 or 3 months ago, right? Not now.
When I was chief, I would try to give at least 1 to 2 months advance warning if I saw something was going to happen. And to be perfectly honest, because of the dramatic retrogression in both India and China, I would not be surprised if they did not impose a rest of world final action date
Ouch.
late in the fiscal year, because they may have used allowed too many numbers to be used by China and India in relation to what they needed to have available for the rest of the world. So again, I would not be surprised if there is a rest of world date at the end of the year, but I would expect if there was, that there would be a complete recovery for October. But this illustrates the fact that if an applicant is scheduled for interview, they should always attempt to do the interview. And if they happen to be refused, overcome their refusal in the month of that original interview and try not to reschedule for a later month unless there is no alternative.
So this is a shocker, right? I mean, Joey, we've never seen ROW unavailable, or we've never seen a final action date with ROW, like, ever,
USCIS, correct. Yeah, correct.
right? I mean, this is just, you know, if you come from China and India, you're aware of the waiting line. Maybe if you come from Vietnam, you've heard about it. But if you come from Korea or Taiwan or Hong Kong or one of the other moderately popular places, those folks have no idea about waiting lines and, just assume they can do concurrent filing. But once you retrogressed, you can't do concurrent filing. And the other issue, of course, is child age lock-in. But we'll deal with that a little bit later, since it's another complicated topic. But this is huge, this warning. And folks in the industry, you need to take this seriously, with the possibility it may also become necessary to establish a final action date for rest of the world countries. That's the punchline. And it feels like a punch in the face, quite frankly, even though it hasn't happened yet. But when it does, it's going to create huge anxiety for all those other countries. And I think we need to heed Charlie's warning. Oh, well, that's an inconvenient date for me. The kids are at school and I need you to reschedule. And I'm like, we've got to start saying, you reschedule and you're going to have some problem getting your interview this year, maybe next year. And, you need to go for it, is the bottom line. Do not reschedule because of this warning, is the bottom line, right, Joey?
Correct. Get your visa. Don't delay.
And file your AOS right now, if you can, adjustment of status, because you may not be able to moving forward with rest of the world retrogression, something new in the industry.
I think people are sort of feeling the pinch of wanting to file before, and get their spot in line, get their priority date. But then they're also weary of impending visa backlogs, what the gold card may mean, giving up so much cash. It's a huge decision to make. And so that's why, you need to work with a good immigration attorney who will help guide you throughout this process. It's not a short-term process. For
Yeah.
Chinese and for Indians, this is a multi-year, we're talking potentially up to a decade-long process. And you need someone who's going to be there throughout it to assist you as things happen.
It always makes me laugh that these people sort of dive into the industry and then 1 or 2 years later they've gone, and then everybody's scrambling looking. We've been doing these cases. I like telling people I did my first EB5 case in 1993. It is a long ride, and having a lawyer who is going to look after your interests and protect you and have, most importantly, the cutting edge knowledge. I'm clearly bragging here, but honestly, without Charlie advising us, I feel we're driving blind, because you can't just rely, assuming you understand the Visa Bulletin, which very few people do. it's like reading tea leaves. And other than Charlie, I don't think there's anybody who really understands this at the level we do. Now, Joey, I know you wanted to spend a fair amount of time on this because this is the reason why. This is May 2024, so it's not exactly current, but it gives us some idea of the number of cases pending from 2015 for China. Those are the operative years, 2016. And then looking at India, there's not that many cases in 17 and 18, right? So one would have thought they would have cleared those 17 and 18 cases out, 2017 and 18. But Charlie, do you want to comment on how to read these numbers?
Yeah. First, if we look at the China figures, these totals indicate the amount of applicants with petitions on file at the National Visa Center. These applicants would be competing for numbers. Again, the fiscal 2025 unreserved annual limit is approximately 11,200. So, even if the rest of the world only needed half of those numbers, the fact that final action date for China was in the middle of 2016, these totals kind of illustrate that that was overambitious. One thing is, if you will look at the rest of world demand, the period of calendar year 2017 through 19 was the peak time when these petitions were being filed. The fact that the categories for India and China have retrogressed already is a strong indication that a large amount of these rest of world applications and the petitions that were filed have been approved, and that is causing an influx of number use, which this is a glimmer of hope for the China and India applicants. If the vast majority of these 6,129 applicants are going to be processed in this current fiscal year, and many of these would have been processed in 2024, this could be a good thing. We're basically cleaning out the rest of world demand, and then that would leave larger amounts of numbers that are, quote, otherwise unused that can be made available to China and Indian applicants as we enter fiscal 2026 and beyond. So again, this may be a glimmer of hope for the Chinese and Indian applicants.
That makes a lot of sense. Joey, you starting to get a lot of your 2019 ROW cases cleared out, rest of the world. So that 3,400, which is a pretty high number, has had a good dent. And you think that's what's driven this retrogression for China and India, primarily,
Yes.
just to put it in simple terms.
Because as this chart shows, this is the latest information released by the State Department. But again, it showed how many applicants were pending. So a lot of these things could have been cleared out in the past year.
So just to defend your former colleagues, the ones you trained, Charlie, so if they don't get it right, it's your fault. Sorry, I'm being mean here. But at the end of the day, they may have been caught a little unaware of how many 2019 ROWs were getting scheduled and just sucked out a large number of the unreserved visas. And I think that's accurate, Joey. I mean, suddenly they started approving all these 2019 cases that had been pending. Our clients were so frustrated because, COVID and da-da-da-da. And then now they got their green cards, but that has caused an imbalance in other areas for the Chinese and Indians. And the fact that the Chinese and Indians have lower priority dates doesn't really help them because of the per country limit, right, Charlie?
Correct. Yeah, the per country limit for this fiscal year for China or for any country is approximately 785 numbers. So
they depended on leftovers at the end of the day.
So what state would have looked at is they know that China and Indian applicants would use their per country limit. They would subtract those numbers from the overall limit. It would have been approximately 9,600 numbers remaining for rest of world use. They may have originally assumed that rest of world would only use 5,000 of those numbers, and they would have had an extra 4,600 to distribute to China and India. Suddenly they realized, whoops, we're not going to have as many numbers to distribute.
Well,
but again, it's very possible that State Departments need to recover from their family, an immediate relative, and numerically controlled family backlog developed during COVID, that they worked off that backlog and now are able to address the employment cases, which allow them to use many more rest of world applicant numbers.
Well, hats off to IPO and to DOS on moving those 2019 cases, because my clients were very frustrated. We were anticipating about 3 years and they ended up waiting 4 to 5 years, and they complained to Joey all day, every day. That's why Joey got gray hair, I think, because of those cases that finally got moving. All right, I'll stop insulting my partner and making bad jokes, but I think he looks better with that. So let's move on to Charlie, this is where like my head starts spinning, but let's briefly talk about, how 202A5 capital A works for unused numbers and availability, how they calculate this in a nutshell, sir.
Right. This is based on an example on the reserved annual limit for fiscal, say, 2025. So if the limit was 4,400 numbers, the China and India per country limits would be 616 each. And then state would make an estimate, okay, how many numbers do the rest of the world need? And they would subtract both the per country limit for India and China, the rest of world number, and they would see, okay, there's going to be 1,500 numbers, quote, otherwise unused available. Those numbers could then be used by China and India applicants in priority date order. And this would allow both the rest of world, China, and India final action dates to remain current, which is a very good thing. Again, the 1,500 numbers, those are extra numbers above, can be used above and beyond the normal per country limit.
And that's what China has pretty much relied on almost from the beginning of the program, right?
China has used probably on average over 45% of the EB5 annual limits. In the early years, as high as probably 75% of the numbers. So again, this is a very beneficial thing to Chinese applicants who typically have the earliest priority dates.
But Joey, realistically, at least what I'm seeing, quite a lot of like Canadians, Brazilians, Colombians, and other people are sort of discovering the program. Nigeria, countries and ROW usage is coming up because they're just not seeing other ways. And this could be another factor impacting the China-India availability, right?
Absolutely. And a couple things. One, I think the gold card proposal's actually it's spurred people towards EB5. I don't think it's gone the other way. I think it's, spurred demand. And then Charlie's always made this really good point about how, the demand for pre-RA kind of came in waves as countries understood and learned about EB5 and markets were opened. Here it was kind of like everyone got to file at the same time. And so that is sort of playing out a little bit differently in the Visa Bulletin than it was for the unreserved.
And then, Charlie, moving to this next slide about otherwise unused numbers, let's just run through that quickly.
Yeah, again, if we start with the normal 4,400 limit, that the per country limit for both India and China would be 308, which comes to the 616. You subtract that. Then state would make an estimate. Okay, I think that there's going to be a need of 3,784 numbers from applicants the rest of the world. When you factor that out, there are 0, quote, otherwise unused numbers. And this means that both China and India don't have the availability of any extra numbers above their normal per country limit. And this is what has happened in this current year. This is what is driving the retrogression of the April dates. Although different numbers are involved, they made the calculations when they were doing the determination of the April dates and said, oops, we don't have any numbers remaining otherwise unused. We have to retrogress the India and China dates. Can't let them use any more numbers.
So this is a hypothetical, which explains the note E, right?
Right. These are strictly hypothetical cases. And this is why the reserve dates remain current throughout fiscal 2025. And I would expect the dates to remain current through the summer, if not through September, the end of the fiscal year, because I just don't think that there's enough approved cases to utilize all the available numbers.
So for those of you out there, please share this information with your friends and colleagues. This is why Charlie is and has been referred to as Nostradamus, the only one who can predict the future, because nobody understands all of this complicated stuff. Even as I'm participating with you, kind of makes sense now, but I know tomorrow it's all like jumbled. So, folks, and this analysis applies not only to EB5, but EB1, EB2, EB3. So I want to give a plug. Our firm WR does 2 programs, at least 2 well, we do many different programs every month, but we do 2 with Charlie focused on the Visa Bulletin. We do employment-based 1, 2, and 3, and we do the EB5 program. So if you're interested in an employment green card, then you got to watch Chatting with Charlie. Just do a quick search. Please share this with your friends. And for those of you who are not watching Chatting with Charlie, you are massively impacted by number availability, but you don't really know what to expect, because the Visa Bulletin is a snapshot of what's going on today. It doesn't tell you what's going to happen tomorrow. It's kind of like, yeah, that's relevant, how much money I got in the bank today, but the question is how much money I'm going to have at the end of the year when I paid my taxes and blah, 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 how much is left. So
Yeah,
that's
that's a really
why
it's
it's
a
so
really good transition because actually, sorry, I just want to say one thing, Bernie, why this is so important is that this this rest of world demand and that unknown is one of the big reasons why we can't estimate with a lot of accuracy what wait times are going to be because it's so dependent on how many leftover visas are available. If that number is big, then you can clear out a lot of the China and India cases that were filed in 2022, 2023 that will lower the time that it's going to take someone filing today.
so
So that's all, they all balance each other out. And that and I-5260 processing times, another unknown, we have sort of seen it start to slow down a little bit. Those impact when there is demand available for the Department of State to see. And so that impacts their decision making only at that time. So it's
So a lot of lawyers and other people, they use the Visa Bulletin to say, oh, look, it's a 2-year wait line, or oh, there's no waiting line. But that is false.
inaccurate.
It's misleading, it's false, and the only way to get accurate information, pardon me giving this blatant plug, is to listen to Chatting with Charlie, where at least Charlie can read the numbers to the extent that we have current information. Now, Joey, some of this is even based on older information, and I know you've recently just filed another FOIA to try and get the most up-to-date information. So, again, I'm just doing a plug for your program that you do every month, which provides the most current up-to-date information on visa waiting lines. And then, Charlie, you do another program with our partner, Sharina Garcia, in the employment 1, 2, and 3. We get quite a lot of criticism. Well, why don't we do family as well? Well, to be honest with you, sometimes we mention family, but the family lines just are hardly moving at all. So I'm not sure how much there is to report and how much there is to predict. But so, Joey, summarize for us, and I know we've been through this slide, determining the final action date. This is what Charlie's been talking about. Give it to me in one sentence.
Or if demand exceeds supply, there's a final action date.
It's a supply and demand thing. Not too complicated, right?
Yeah.
And demand exceeds supply, you have a final action date. And final action date, again, for those who aren't that familiar, is when they can actually issue your green card. That's what I call Chart A. Chart B is get ready for your green card. So here's the takeaways from our April 2025, what I'm going to call the shocker Visa Bulletin. It's going to be one of those scary things. Charlie, would you just summarize for us again what your key takeaways are for this April Visa Bulletin? And I know we're now repeating some of what we said.
Yeah, again, the Chart A dates for all three reserve categories remain current as they have been since the inception of the program. Based on the best information available this time, I think that the dates will be current through May, probably, and if not through September, which is the end of the fiscal year.
I'm going to stop you right there quickly, just so people can stop and absorb that. That is the single most important statement in the RIA industry right now. Everybody wants to know what you just said. And I'm going to stop and repeat it, even though everybody heard it. The three reserved categories, we use the word will, we maybe should be using the word should, because we don't know for sure, remain current through at least May, if not through September. That is the end of FY25. So why that's so important is you've got a few months to file your adjustment of status. You have a window of opportunity that is going to close. You do have limited visibility, Charlie, I understand, but you're making this prediction, which is incredibly valuable for people lawfully in the United States planning to file for an adjustment of status. I just had to stop and explain, because that is the information everybody wants to know if they are in the US. Pardon that interruption, but back to you, Charlie, to complete your April 25 takeaways.
Yes, and again, the reason I said that when the leaving things current is I just don't believe that there are enough approved petitions. We're seeing limited actual number use in the reserve categories so far. And so I believe that there would have to be a dramatic increase in the amount of petitions approved and number use. And also it's important to remember that a petition may be approved, say now, but it may, before the applicant is ready for scheduling of an interview or final action on an adjustment of status case, it would typically be several more months. So again, I just don't think that there's enough demand now. And a final action date should only be imposed by the State Department if past number use plus current number use is estimated to exceed the annual limit. And I do not believe that will happen based on current number use patterns.
I want to throw a question to you, Charlie. We have twice as many rural petitions approved versus high unemployment. Now, there's twice as many visas available for rural versus high unemployment. So everybody's been running to the rural because there's twice as many visas available. But now they seem to be almost a balance. Is it not accurate that as of today, high unemployment, I mean, we don't have that much data, that a high unemployment category might be just as good as a rural category based on the number of approvals. Is that more or less accurate, Joey?
Well, I'll say this. In theory, yes, just because there's more supply doesn't mean that there can't be more demand in the other. And I guess the other thing I would say is rural's getting approved faster. So we are seeing I-526 for, rural petitions. That demand for those rural numbers, I guess, are coming in quicker than they would be for high unemployment as well.
So
USCIS
if you're doing an adjustment of status, do you really care? Right? I mean, maybe you want to get your case approved before 27 or something, but at the end of the day, the number one issue really is, are you going to get your green card? But the second issue, because they both number one, is am I going to get my money back? And a lot of people feel the high unemployment projects may be safer than the rural generally.
I would say that
We don't do financial analysis.
Yeah, you can get the full EB-5 immigration benefit and lose your money. And so you got immigration due diligence is incredibly important because it's the basis for your green card, but it's not the full story. You also need to be doing your financial
And
due
I'm a little
diligence.
worried that some people are forgetting to do the financial analysis. They're looking for, which is the project that gives me the lowest admin fee? Which is the cheapest lawyer I can find? Try and save $1,000 here, $2,000 there, penny wise and pound foolish, because the most important thing is to make sure you work with a solid project that gives you your green card and your money back. And I think that's an important evaluation. Sorry to go back to the basics, but let's, Charlie, carry on with your prediction number 3. Expected final action dates for high unemployment.
Yeah, I would expect, we're many years into the program. In theory, by October, one would expect that there's enough approved petitions in both the rural and high unemployment areas to allow number use to be maximized. If that were the case, then I believe that high unemployment area final action dates may be required as early as October, and in the rural categories, no later than January. I would also like to add another glimmer of hope. It's important to remember that many applicants are approved and rest of world applicants have the option of opting out of reserved processing. And if the unreserved final action date proves to be more advantageous, they can opt out of processing in reserve and request that their case be processed in the unreserved category, where the annual limits are going to be dramatically higher. So this dynamic has the potential to kind of play havoc with trying to estimate movement of final action dates and the imposition of application dates going into fiscal 2026 and beyond.
So we're going to run over time a little bit because I talk too much. But so Joey, help me with this. What Charlie was just talking about is the option to go for unreserved. We know how to do this by notifying NVC if you're processing abroad. How do you do this if you're filing for an adjustment? Do we have any idea? You're the vice chair of the ALA committee.
Yeah, we're trying to work with USCIS headquarters. It's actually not an IPO issue. It's a service center issue. And so we are working towards that. The IPO doesn't seem.
Would you recommend just sending a letter to
Oh, yeah, that's what
them?
we're working. Yeah.
Send a letter to and say, I hereby wish to choose unreserved, blah, 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 to let them know? Or
Yes,
don't-
we do that. It doesn't seem to be working. They're just approving these without, well, they're current right now. So there's no, either way, we wouldn't really know. I guess maybe on the card itself it would say so, but everything that I've seen has been RR or RU.
So they just haven't worked it out yet. All right.
Yeah, and this opt-out is not an issue at this time. As long as both the unreserved and reserved categories remain current, there is no reason for a reserved applicant to opt out at this point.
So let me ask you another question, Charlie. We know about opt-out in the family context. So you can opt out. My question is, can you opt back in again after you opt out?
Yes.
So you can go backwards and forwards and backwards and forwards, assuming the government actually gets your notification.
Yeah, this was a big issue with the family 2B applicants who their parent became a U.S. citizen. The 2B category they'd fall into the family first preference, and sometimes that was disadvantage to the applicant. So they would opt out of family first, continue to be processed in family 2B, and if the date changed again, they could switch. So again, this opt-out will allow applicants to move back and forward with the, processing time involved in this.
And that's clearly explained in the FAM, right? The Foreign Affairs Manual has got it, but it doesn't have it for EB5 yet, but they have it in the context of the family.
Yeah. So this would be similar to applicants who move up and down between the EB2 and EB3 categories in a way.
Right. So you can pick and choose. I mean, it's not sort of automatic, but you do have the right to choose the most preferable category, and you can clearly switch between reserved and unreserved as you can between EB1, 2, and 3, right? You can go up and down, carry your priority date, but for those, you have to refile a petition. Here, you're just opting in, opting out. And this is more analogous to the family first and 2B options. That family first is unmarried child of U.S. citizen. Anyway, let's keep going. This is big stuff, and hopefully we can run over a little bit. EB5 limits with carryover. Charlie, what do we got here?
Again, this is just showing the the overall limits and the EB5, the per country limits, et cetera, and potential carryover. This is one of the advantages of the reserved categories, that the unused numbers from the previous year carry over for 1 year to the next fiscal year. This would have been a much more advantageous thing if there were enough approved petitions to allow the carryover numbers to be utilized. If the carryover numbers are not used in the following year, they are then added to the unreserved category for the next year. It's a little confusing, but again, this carryover provision is very important for the reserved categories, potentially providing more numbers than would normally be available.
So, I mean, in a bottom line is everybody thinks this is a 10,000 a year program, but for fiscal 25, it's almost 20,000, correct?
Correct.
So this is a fairly abundant year, and yet still we're seeing some scary retrogression in the unreserved category with some potential warnings for the reserved category that we all need to be cognizant of. So, Joey, slice and dice this. This is actual number, including up to fourth quarter. So that's through to December of 24, correct? And what are your key takeaways here, Joey?
Okay, I got a few key takeaways. Number one, if you look at first I'm going to go from bottom up. If you look at the fourth quarter, you can see how many cases for the 956 have been denied versus approved.
So if you filed an AOS and your 956F got approved, what happens?
That means they have the ability to approve your I-526E. They will not approve your I-526E until the project that you have invested in has an approved I-956F.
And if you filed an adjustment on top of it and you don't have underlying status, you could be high and dry, is what I'm getting to.
If the 956 is ultimately denied, then yes, that could be an issue. So that's one thing to look out on, and something to be considering is 956F, making sure that the project documents are compliant.
Is that driving the concept that people don't want to file unless they have a 956F approval?
It's one of the ways that you can mitigate immigration risk. Yes, I think it is something that people are looking for. Now, it doesn't mean that those regional centers that have pending 956s, there's nothing necessarily wrong with their projects or it doesn't comply. It's just a matter of timing. But yes, it is impacting decision making, I would say.
So be careful about your underlying status if you're choosing a 950, a project that does not have an F approval, is my point.
Yeah, exactly.
Got it.
For I-829s, I'm just going the next highlighted line up. You could see that is significantly more approvals than denials. And this is very much consistent with our practice. We get approvals pretty much all of the time with I-829s. Unfortunately, we do see denials, and we're starting to see them for project-related reasons. We're seeing them for source of funds-related reasons, and it's very scary for these folks, and NTAs can be issued.
That was where I was going to butt in and interrupt you, as I rudely do. Joey, they seem to be issuing a lot of notice to appear in immigration court when you're A29. This isn't just, oh my gosh, I got a denial. This is the government is now actively moving to remove you from the US. And one more thing I saw, because somebody reached out, it's not our case, thank the good Lord, but somebody reached out to me yesterday, and in the 829 language, it says, and your right to be employed in the United States is hereby terminated. I think that's wrong based on the regs, but it's in the denial notice, and it's scary as hell. These people have to stop working once their 829 goes down or challenge that notice.
Absolutely. It's a huge issue, but the policy manual is very clear that you can continue to work, you continue to get I-551 stamps until a final order of removal by an immigration
good luck
judge.
Explaining that to an officer at the airport or the Social Security office when you've got this denial and it says you can't work, and technically then you can't travel either because they revoked the work permit, and you're still supposed to be a conditional green card, but at the end of the day, it's unclear because the manual.
There's some ambiguity there. It's very, you're in limbo. It's a limbo state. It's not a good place to be.
But you need to hire a deportation lawyer is the bottom line, because you're probably going to be in removal.
Yep. And the next thing I just wanted to point out with the I-526Es is that, well, one, you can see that they're receiving significantly more than they're completing, and that you're seeing really a high number of approvals, very few denials, which is great. And that is consistent again with our practice where we're seeing honestly a little bit less scrutiny, I would say, on some of the same issues for post RIA than we are for pre RIA, surprisingly enough. But really, what I wanted to show was that in 3 months, they only adjudicated 382. And that gets to our point that they're just not adjudicating enough of these cases in order to meet the limited supply or the supply of visa numbers that are available this fiscal year.
Because I'm not as sophisticated as you, Joey, I look at this and I see 1,025 526Es approved. That's not a lot. I mean, that could take 4,000 visas. So, you know,
And that's in a fiscal year. That's for over 12 months.
exactly. So my question is, if you applying under the reserved category, that's not a lot of cases approved, which means there should be visa numbers available, which means the final action date should remain open based on that low usage, right? So that's
That's
for me the most important statistic here is the 1025 for 526Es for the year to date.
yes.
And I would like to point out that with the earlier, when I mentioned the October fiscal 26 potential, that is in a worst case scenario, as you see here. As you mentioned, the 1,025 approvals, that's not enough to use demand. So the fact that they are not approving petitions at a high rate means
saving
that
us.
the final action dates could potentially remain current well into fiscal 2026.
Which would be amazing for people being able to file adjustment. But Joey, that now means it could take them several years to get their green card
Yeah, I
because
mean,
we
it's
filed all these adjustments. But nevertheless, very good news for those Indians and Chinese in the US. And that's why we having a little, I think, Joey, you told me you're signing up a ton of Indian H-1B cases because this is the path, this is the door that's open right now, based only on the fact that even though there's a lot of cases filed, only a few approved, less than a quarter approved, that's keeping the door open for more AOS cases, but some of them might be stuck in a waiting line, right? That's the takeaway from these numbers.
Absolutely. You will be stuck in a backlog, but you also get to remain here. You get to have your EAD and your advanced parole. I mean, I talk to people who have very good jobs who are not being impacted by the current layoffs, who kind of see the writing on the wall. They see H-1B reforms, they see AI coming into their industry, and they want a backup plan for, if and when this is going to happen. And now is the time to get your spot in line and to get that interim benefit of the EAD.
So if you do your concurrent filing and you get your work card, you can open your own business. You can have one job, two jobs. You can potentially
Hang out on the beach and not do anything.
I was just gonna say, hang out on the beach and be in Hawaii drinking Mai Tais. Yeah. So this is, I think, one of the reasons why our adjustment teams are so busy right now. We've authorized overtime for them, and it's really pretty good fishing at the moment. So let's summarize. What do we see on monthly immigrant visa issuance statistics? Charlie, do you want to decipher?
First,
what
I just have to say we stole this from Suzanne, so I got to give a
yeah,
shout out to
wait,
Suzanne.
wait,
Yes.
wait. We need to give who's Suzanne? Who? Suzanne Lucid. You know what, folks? Joey's blogs are amazing, but you've got to read Suzanne's blogs as well. And Lucid, well, thank you for giving Suzanne credit for this. What are your takeaways on this one, Charlie?
As I mentioned earlier, the China and India annual limits are approximately 785 in unreserved. You can see China through December received far in excess of that. India is lower, so I would expect that when the January and or February data is published, India would be up there. And you see that the rest of world number use is high again. So this has caused the retrogression of the China and India dates, but you will see extremely low almost non-existent use of numbers in the reserved categories versus the annual limit. Again, this is why I believe the categories are most likely to remain current through the end of fiscal 2027.
But Charlie, this is just dealing with processing abroad, right? This is immigrant visa. It's not including AOS adjustment numbers.
Correct. And the use of reserved numbers in the US is likely to be significantly higher than number use in the unreserved categories. So these are a little bit deceptive, but it's the only thing we have available. Luckily, Suzanne, through her FOIA efforts, have gotten this data. Joey's doing FOIAs to get information. Unfortunately, much of the data which is required for more in-depth analysis is not provided without the use of a FOIA. So transparency is not what we would hope for.
And I'll just say this, the January data did come out, and so there were only 90 more unreserved visas issued to India, so 400 total. And then the other sort of significant thing is that 860 to Vietnamese, right? So that's also over their annual limit.
So
Yeah,
that,
so that
was a
means
surge
yeah,
for Vietnam.
with that Vietnam total, then Joey, then in theory, the State Department should have potentially consider imposing a Vietnam date, but I'm not sure that they would do so based on their interpretation of
Right.
how they can have numbers fall down.
Right.
Yep. So, folks, this is complicated stuff. At the end of the day, as I said, I think Charlie and Joey, the two most knowledgeable people in this arena, crushing the numbers together with Suzanne, who does a pretty good job out there with her blogs that everybody loves to read. A lot of good information in there. But this stuff is super important. I try and make it simple because I do not have the firepower of Joey and Charlie. Please, folks, share this amazing information. It was such a pleasure to join you,
Thank you, bro.
Charlie and Joey, and try and add a little entertainment to this somewhat complex stuff. Joey, do we have any questions that we can try and sneak in? I love answering everybody's questions.
Yeah, here's a good one. I know there's always risk, but would you say re-entering the US with advanced parole has become riskier in the past month or so? I want to travel with it, but I'm a little afraid to do so.
So, this administration thinks that too much parole, that the parole authority has been used too broadly. There are over 500,000 people from Cuba, Venezuela, Haiti, and in Nicaragua. They've revoked all of those people's parole. I don't think they're going to revoke your parole. Parole entitles you to come back to the United States. It's got to be revoked. I think you're safe. But you know what we have seen? Look, you're going to go to secondary on that advanced parole. And secondary is always a little bit scary because they're going to ask you some questions. But as a practical matter, I'm not seeing big problems with regard to the advanced parole. As of the present time, it is safe. But, if you happen to have been engaged in activities that the government doesn't like, you're going through secondary inspection. So the question is, they will ask you, what are you doing? What are you involved in? So just make sure that you are compliant. If you have an arrest warrant, for example, for a DUI, and you go into secondary, yeah, you got a problem. So make sure that the runway is clear before you take off and fly. So I'm saying advanced parole is okay. The one that I am having some issues with is before I would say there was no limit on the amount of time that you could stay out. That rule hasn't been changed, but I'm not sure it would make sense to be out of the country for 4, 5, 6 months. Joey, what's your view on that one?
I've always advised people to not be out for more than 6 months. I think I've sort of taken it from you just to be more conservative on this. I think the government wants permanent residents to be in the United States. They don't want people using a green card like a tourist visa.
And yet they're not permanent residents because they are still pending adjustment, but
Oh, I'm
Yeah.
sorry. Yes, with advanced parole. I advise folks to maintain your underlying non-immigrant visa status as long as possible. If there's
If
emergency,
you're on an H1, stay on the H1. If you're on an F1, pay your school fees. That's the very safe, conservative view to, have a safety, have a parachute, have a escape route if a problem emerges. So I'm totally with you on that, Joey, that it makes sense to maintain underlying status, but it's not legally required as of the current time, although adjustment of status pending is not a status per se. So, you are in a fairly vulnerable situation. So, Joey, I love your advice. If you have valid non-immigrant status underneath it, keep valid. But if you're on a B2 and you applied for an adjustment, there's no real way to keep your underlying status unless possibly if you switch to an H1B, which not many people are doing, but it wouldn't be stupid to do that, right?
if you could find an employer or something. Yeah.
Yeah, or if you have an employer, I'm assuming you have an employer and you have an EAD, maintain underlying status. It's extremely conservative advice, but I think in today's environment, one can't really be too conservative. Joey, any other last question there? And then we'll call it quits for today.
Yeah, the only last one, it's for a Charlie. It's talking about Chart B movement. Do you see any Chart B movement for October for China in the unreserved category, I believe they're talking about?
No, I would not expect any movement of the current China application filing date, and I have some concern that it may actually be retrogressed from the current October 1st, 2016 application date.
Ouch. I didn't want to end on the negative note because October 2016, there's a lot of people in 17 hoping to get there, but you got to call it the way you see it, Charlie. So let's hope you're wrong on that one. But the sad news is you're not often wrong. So on that somewhat downer note, thank you everybody for joining us. This is the only place where you can get, besides Suzanne's blog, the most up-to-date information and analysis. And maybe we should invite Suzanne to one of these as well. And sorry, I drag things out a little bit too much, but I've got to make it clear so I understand it. Charlie, thank you so much for your wisdom and foresight. Joey, thanks for your practical advice. And from Bernie, I apologize for talking too much, but I've got to get the stuff clear in my head, and it's sometimes quite complicated. So that's all we have for today. Please share, please like, please do all the other good stuff that social media needs, and reach out to WR Immigration for all your immigration needs. We're a firm with 10 offices, almost 200 staff, and we haven't spoken about Rapid, but we do have the best technology in the industry. Boy, am I a braggart. Thanks, Joey. Thanks, Charlie. Have a wonderful rest of the month. And thank you, everybody, for joining us today.
Thank you, Bernie.
Take care.